Since the days of John the Baptist, the kingdom of heaven has suffered violence, and the violent take it by force. Today, we want to talk about how the government can take your land by force. We want to talk about compulsory acquisition of land in Nigeria. Compulsory acquisition of land in Nigeria. You'd be surprised if you don't know already, of course, that the government can actually take your land forcefully, in quotes, because it's not actually forcefully, because it has legal backing, and that's why we're talking about it today. Let's talk about forceful acquisition of land and what the law says and what your options are as a private individual, an owner, landowner in Nigeria. We're going to be looking at what the Constitution says, what the Land Use Act says, and of course there are laws of various states as well that talk about compulsory acquisition of land. This is Battle with the Law. Subscribe if you haven't subscribed. Like the video when you've seen it, and please leave comments in the comment section. By all means, share this video far and wide, and don't forget that you leave comments in the comment section. We respond as soon as we can. But if you need paid consultation, a tailored answer that is only beneficial to you or to your situation, you book a paid consultation using the link in the description box. Thank you very much. Compulsory acquisition of land by government just means government's takeover, compulsory takeover or forceful takeover, force in quotes, for overriding public interest or for a public use or public purpose. So what it means is that there are instances where the government needs land to do something that will benefit the entire citizenry. In those instances, they can take over the land of a private individual within the bounds of the law. Now let's look at what the law says. If you check section 44 of the Nigerian Constitution 1999, it tells us that you have a right to own land, and that land cannot be taken away from you except followed by due compensation. So that means that the right to own land is inalienable, just like every other fundamental right. Land, a right to own property. But in the instance of a government seeking, maybe state, federal, or local, seeking to take the land from you, they must compensate you. Let me read that section of law to you for the avoidance of doubt. Section 44 of the Nigerian Constitution says, and I quote or I read, "No movable property or any interest in an immovable property shall be taken possession of compulsorily, and no right over or interest in any such property shall be acquired compulsorily in any part of Nigeria except in the manner and for the purposes prescribed by a law that among other things requires A," that's subsection A now, section 1, "requires the prompt payment of compensation therefore, and B, gives to any person claiming such compensation a right of access for the determination of his interest in the property and the amount of compensation to a court of law or tribunal or body having jurisdiction in that part of Nigeria. 2. Nothing in subsection 1 of this section shall be construed as affecting any general law for the imposition or enforcement of any tax rate or duty, for the imposition of penalties or forfeiture for breach of any law, whether under civil process or after conviction for an offense, relating to leases, tenancies, mortgages, charges, bills of sale, or any other rights or obligations arising out of contracts relating to the vesting and administration of property of persons adjudged or otherwise declared bankrupt or insolvent, of persons of unsound mind or diseased persons, and of corporate or unincorporated bodies in the course of being wound up." So essentially what this section says is that your land can be compulsorily acquired, but it must only be done within the bounds of the law and with due compensation given to you. Now the law, it says within the bounds of a law, that amongst other things, then it lists the other things. So that law is the Land Use Act, which we are going to look at. There's also the compulsory acquisition law. Some states have it. I think all states should have it. I've seen that over your state because I had course when I was a state council. I had course to advise on such acquisition. I think I talked about the matter here because it went to mediation, and then we had to also advise on the matter. I wrote a legal advice. I think that was the second or first legal advice I wrote as state counsel, so I clearly remember it. I also remember the mediation that had to do with compulsory acquisition, which I'm going to be talking about much later in this video and it was a very contentious and a very funny situation. Human beings are very funny when it comes to land and ownership of land, but we jumped the gun. What subsection 2 of section 44 is saying is that this compulsory acquisition is provided for, but it is not to be misconstrued with you losing your land because of, or losing your property. It could be houses, it could be any other thing, not just land, but really immovable property in this wise, usually land, mostly land. You losing it in case of, because why I say other things, it could be land that you've developed, you've built something on it. So, but basically mostly land. We're talking about compulsory acquisition of land after all. So what 2 is saying is that for other things, for instance, maybe the land is being taken away or taken over in a forfeiture process or proceeding, or in as regards maybe insolvency or bankruptcy, or all those, or in breach, maybe it's a penal forfeiture or a penal acquisition, maybe all these other things that are listed, they are not concerned with subsection 1. Subsection 1 is talking about you having your land, you've not breached any law, you're not owing any rates or taxes, you're not insolvent or bankrupt, it's not relating to a lease or tenancy or mortgage or whatnot. You know how if you default on your mortgage, the bank can take over your property. That is not the acquisition we're talking about. The one we're talking about is that you are good for money, good with the law. You own a property and the government wants to take it over for public interest, for overriding public interest, or for a public purpose. That is where the law is saying that you must be compensated, 1, and B, that's subsection 1B, saying that you must be involved in the process of determining what your compensation will be, and you can come before a court to appeal or to review the compensation, to argue, for instance, that, oh, maybe my property is worth 11 million naira, why am I being offered 5 million naira by the government? Usually when acquisitions are being done, you are expected to value the property. I think I was involved, the one that I know about, you would value the property, you get your own valuer, and the estate valuer, most likely they will value it. You submit your valuation to the government will also value it, and then they will reach a consensus. So ordinarily, if you're valued right, your figure or what you're asking for will be close to what the government is offering. It will be close, or it may be the same, but there may be discrepancies which will not be too far from each other. But if you're trying to scheme the government, scheme some milk of the government, you're trying to make money of the government, they also have their valuer that will value it, and it will be so clear that this is the actual value of the land, and that's what you're going to be offered. We're going to look at the Land Use Act, which also talks about replacement. So it's not just paying you off in compensation, they can also compensate you by giving you another piece of land, another property elsewhere, to substitute for what is being taken from you. But so that we do not jump the gun, let's talk about public interest, overriding public interest. Now, what happened in the mediation case that I talked about? What happened was that according to the complaint that was filed, the government had started constructing a maternity, that's a clinic for pregnant women, in that locality in Nigeria. They had started work, and they had constructed a 38-bed facility. I think it was up to lintel level at the time. And then one man in the community had bulldozed the property, bulldozed the construction to the ground, after having given the construction workers a lot of problem, and the community as a whole a lot of resistance. According to him, he was saying that the property, the land is his, and the government had not acquired it from him properly. They had not compensated him for the land. So it was essentially claiming that the land that the government is trespassing, not that they had compulsorily acquired the land. The government was saying that they met the community, that the land was community land, and that they had paid the community. No, they had not even paid the community, according to the story, because the community was represented. The community said that they agreed that the government should build the maternity on that piece of land because it serves the community. It would benefit their pregnant women for ages to come, and then they would employ their children too. in that facility, they would employ them probably as nurses, as ward aides, as assistants, around the maternity, as gatemen, as cleaners, as whatnot. So it will provide job. And of course, the construction also would provide jobs for their children who were into construction in the community. But the man was saying, it's not community land, it is my land. And government has not paid me. They have not compensated me. I have a right to give out that land, not the community. So that was basically the dispute. And then I advised based on the compulsory acquisition law of the state. I wrote my advice. So essentially, the compulsory acquisition law is in tandem with the Land Use Act. And what is said, according to my advice, was that government can acquire land, but in the case of acquiring such land, there must be proper notice given to the landowner. It must be sufficient notice. Government cannot just come into the land and do as they please. It must be sufficient notice. Also, they must also inform the person, not a third party, or not just publishing it in the news or something. We'll get to that because that's the actual requirement. In decided cases, the court has made pronouncements on that. So the person has to know and agree. Of course, if you don't agree, the agreement is well qualified in the sense that you would agree to the compensation, then you value, the government values your paid, the government moves on, or you get a replacement. But agreement in the sense that you should know generally. Most people would agree, but if you're fighting it, you would lose because the government can acquire land for a public purpose. Also, the purpose has to be public, and then the government will then carry out the public purpose. So several other things, but what we're concerned with in this video is that law of the state tallies with what the Land Use Act says. And so we're going to look at what the Land Use Act says now to explain public acquisition, which is what the Constitution has permitted in section 44 that we read. When you look at section 1 of the Land Use Act, it already states that all land is vested in the government, and that is in the governor of a state. So basically, the government is holding the land in trust. The act was made in 1978. So post 1978, all lands were now vested in the governor of a state, held in trust for the state. So the government would then allocate lands to people who wanted to buy and issue them certificates of occupancy. So essentially allocating to them 99 years, that is renewable anyways. So that's why when someone that has a certificate of occupancy by the state is selling the land, they use a deed of assignment because they are assigning what is left of the 99 years that the government assigned to them to the buyer, the innocent third party purchaser. When you then check section 28 of the same Land Use Act, it talks about revocation of that certificate of occupancy for overriding public interest. Let me read it out to you. It says, it shall be lawful for the governor to revoke a right of occupancy for overriding public interest. Overriding public interest in the case of a statutory right of occupancy means the alienation by the occupier of assignment, mortgage, transfer of possession, sublease, or otherwise of any right of occupancy or part thereof contrary to the provisions of this act or any regulations made thereunder. Then it talks about the requirement of the land by the government of a state, which is the focus of this episode, or by a local government in the state, in either case for public purposes within the state, or the requirements of the land by the government of the federation for public purposes of the federation. Then it also talks about requirements of the land for mining purposes or oil pipelines. Nigeria is an oil producing state and we have minerals, mining activities, all those things. So if the government requires land for those activities, it can also be compulsorily acquired. The C of O can be revoked by the governor. Also, it talks, for mining purposes. Then it talks about overriding public interest in case of a customary right of occupancy, which also talks about public purposes, mining purposes, extraction of building materials, and then if the land has been sold without consent, or in the event of, that's D, the land has been sold without consent. But our focus here is overriding public interest or for public purposes. So we then move to section 51 of the Land Use Act, which defines what public purposes mean. Public purposes includes A, for exclusive government use or for general public use. B, for use by any body corporate directly established by law or by any body corporate registered under the Companies and Allied Matters Act as respects which the government owns shares, stocks, or debentures. Then it talks about in connection with sanitary improvements of any kind, for obtaining control over land contiguous to any part or over land the value of which will be enhanced by the construction of any railway, road, or other public work or convenience about to be undertaken or provided by the government. It also talks about obtaining control over land required for or in connection with the development of telecommunications or provision of electricity. It also talks about mining purposes, planned urban or rural development or settlement, economic, industrial, or agricultural development, for educational and other social services. So those things are the public purposes for which government can revoke a certificate of occupancy. That is, the government can compulsorily take over your land. Those are purposes. If, for instance, a state government wants to establish a university in a locality. Matter of fact, I was sitting in a meeting, the statutory meeting a few weeks ago, and this matter came up because the lands that had been acquired by the government of a state to establish a university was now being encroached upon by people who were ancestral owners of the land. They were selling those lands. Meanwhile, this land has been compulsorily acquired decades ago, gazetted and all of that, with beacon numbers and whatnot. So in those instances, those sales are void ab initio, because government has already acquired it for a public purpose. The university has been constructed. The public purpose has been executed. Those people cannot come and say that, oh, the government did not use it for what they said they were going to use it for. And of course, those people were compensated back in those days. If you know anything about the University of Ibadan, I was living in a place called Ajibode when I was a student of the University of Ibadan. I lived there for some time, and I learned that that place was a resettlement. When the government acquired lands to build the University of Ibadan, the owners of those lands were resettled. Some of them were resettled in that place called Ajibode. I believe my landlord was one of those people, or maybe he bought from one of those people. So essentially, when land is compulsorily acquired, it is for public purposes. So we must be able to establish that it is for a public purpose, which are things that we've discussed. For instance, when the Lagos-Ibadan railway was being constructed, it could be, or it could have been, that some people's lands, of course, it must have been, were compulsorily acquired. It may not be now that the railway was constructed. It may not be in these recent times. It could be that, when maybe the government made the master plan, or the plan of action for the future, they might have acquired it as far back as decades or even a centenary ago. But Nigeria is not as old as a centenary. I mean the democracy anyways. So if they've acquired it in that period and paid off, compensated or resettled the original owners of the land, or those who held the certificate of occupancy, that's if it was after 1978, the Land Use Act, then they have the lawful right to use the land for the public purpose which it's been designated for, which is what we have discussed. So we've talked about what public purpose could entail. Now let's talk about the compensation. Land Use Act again. If you check the following section, section 29, Section 29 of the 28 provides for the compulsory acquisition, but if you look at 29, it talks about how you may be compensated. Section 29 of the Land Use Act talks about the compensation where land has been acquired for public purposes. Now it says that if a right of occupancy is revoked for the causes set out in B and A or C, subsection 3, those are for public purposes in general, the holder and the occupier shall be entitled to compensation for the value at the date of revocation of their unexhausted improvements. So they are to be compensated. It follows automatically. Compensation is automatic. And then it says that if the certificate of occupancy is revoked, for mining purposes, they shall be entitled to compensation under the appropriate provision of the Minerals and Mining Act or the Petroleum Act, if it is, for oil and gas, oil exploration purposes, laying of oil pipelines, as we have read before. You can get a copy of the Land Use Act. It's free to be downloaded online, and it's just a few pages. You can read it up in one sitting if if you want. So subsection 3 of section 29 says that if it's a community that is entitled to compensation, the compensation shall be paid. The compensation shall be paid to the community, the chief or the leader, for him to dispose it for the benefit of the community, or into a specified fund, for the purpose of being used for the benefit of the community. So if you look further, it talks about, what compensation will be for the type of property that was taken over. If you look at it, it talks about what compensation should be for the particular type of properties taken over. So you can look at section 29 of the Land Use Act. If you check section 33 of the same Land Use Act, it provides for resettlement in lieu of compensation. So that means that if you'd rather that the government give you alternative accommodation or alternative property in lieu of, paying you the value of your land that's been taken or acquired, then you can have that. Now, there's a caveat. The caveat is that if the property that the government is giving you or resettling you into, if the value is much more than what would have been paid had you gone for compensation, the overflow, or what is the value that is more, than what you should have received, will be treated as a loan. So the government would expect you to pay it back as a loan to the government. So the provisions of the law, they are very clear on compulsory acquisition of land. Your land can be acquired. You're entitled to compensation. You're also entitled to resettlement in lieu of compensation. And if the value exceeds what you might have been paid if you had taken compensation, gone for compensation, you are liable, or you are under compulsion by law to return what is in excess of what you should have gotten. So that's the provision of law. Now, in some decided cases, the law or the provisions of the law regarding compulsory acquisition has been expanded, and I want to run through them. You can find these cases online. You can look through them. You can read. You'll find a plethora of old cases on compulsory acquisition, because you know that most or many of government institutions and establishments were built back in the day. So the government needed land for those things, and that's why many of the cases are old. But of course, government business is a continuous process. So there are still things being built today. There are still structures, establishments, facilities being built. So the compulsory acquisition is still a contemporary issue. If you look at Olatunji and military governor of Oyo State, for instance, the court expanded, the provisions and the requirements of compulsory acquisition in that case. The court said, amongst other things, that when the government is compulsorily acquiring land, it must give notice to the individual that owns the property. Not just that it will publish it in a gazette, that's a public notice to the whole world. But the person affected, the landowner, the possessor, the occupier, must be personally notified. So you can't spring a surprise on them. They must be duly and personally notified. Also, the notice must contain the purpose, the overriding public interest that the land is going to be put into use for. It must be stated, such that if the owner or occupier wants to contest it in court, they can go ahead and do so. It must be stated. They must be duly notified, and the purpose must be stated. In Goldmark and Ibafon as well, the court held that personal notice must be served on the owner or occupier of the land, and proper procedure must be followed. So there must be no hanky-panky, especially on the side of the government. Very important. There must be no hanky-panky. So very important, very important. We've talked about the uses, it could be for road construction, for bridge construction. It could be, to facilitate the provision of electricity into a locality or into, a community. any public use, proper procedure must be followed, and the public use must be disclosed, so that if anyone wants to contest it, they can contest it, and so that it will be clear to everyone that this is the purpose for which this land was acquired. So if the government now decides to divert from that purpose, the citizens, especially the landowners, can take the government up and say, no, this is not what this land was acquired for. It is very wrong. I also heard about a case. I'm not certain. I don't think it was my client, because I did not undo that case, but someone had told me about it. How a land in a state in Nigeria, land was acquired, public acquisition for the construction of a public hospital, a general hospital, and then it turned out that years later, government was selling portions of that land to private individuals. So the public use, the public purpose for which the land was acquired, must be executed. Very important. And holders are entitled to compensation. Occupiers are entitled to compensation. They're also entitled to resettlement. In Ereku and governor of Midwestern State, for instance, the governor had acquired by public acquisition land for a Brazilian firm to construct an industry, in the state, and then it was contested in court, and the court held, that the governor cannot do that because that is not a public purpose. The Brazilian firm is a private company, so they should buy land like any other private company would buy land. Government apparatus must not be deployed for personal purposes. Although, on the part of the government, they contested that, this is going to provide jobs for the citizens of the people in that locality, it's going to benefit them in the long run. But the court held that no, it's not a public purpose. That Brazilian firm is a private entity. Let them buy their own land, as a private entity. Let government not be used, to acquire land for them. So there's a difference. The law, the Land Use Act that we read earlier, talks about, government, companies where government is holding shares and debentures, and government establishments in general. So it must be of a certainty that it is the government acquiring it, not just for public use, but the government is the one acquiring it, not an individual or a private entity going through the government. And then, of course, it must be for a public use, not a private use, because the Brazilian company is going to be making money as a private entity. They may be paying taxes to the government. They may even be giving, some sort of how would I call it, back to the government, for acquiring that land for them. But that is not a public purpose. They are not the government. They are not a part of the government. So they cannot be treated as a public entity. So very important, that distinction. So I hope that you've learned a lot with this video. We've talked about public acquisition in detail, what it is, how it is done, what your rights are as a private holder or occupier of land, and what the government should do, what you should do. I hope that it is clear. I will see you in my very next video. Please like the video and leave me comments. Let's continue the conversation in the comment section. Those are fireworks outside my window, even though it is short. It's still, people are still in the festive mood because I'm recording this video on the 2nd of January 2025. See you in the next video. Toodles.